Mr Acting President. Mr Acting President, throughout this pandemic, the government has relied on the state of emergency legislation to impose restrictions on Victoria, to implement legally enforceable rules pertaining to mask wearing, quarantine, self-isolation and a raft of other health measures. Now, every time the government came into this place seeking an extension to the state of emergency, I asked for pandemic-specific legislation which sets reasonable boundaries and required parliamentary oversight to mitigate against abuse of power. So what's the government done? Well, they've gone away and, with the help of a few crossbenchers, drafted an unprecedented piece of legislation akin to firing a nuclear missile to kill a cockroach. And I use that as a loose analogy because the pandemic is obviously not a cockroach. It's a much bigger threat than a cockroach. The pandemic has significantly changed our way of life. But that's no excuse for a government to run roughshod over people's lives and create an intimidating regime that will be an ongoing threat to civil liberties and the freedom of Victorians in the future, especially now as we edge closer to having a fully vaccinated population. I was one who called for a specific health bill, rather than continually extending the broad powers of the state of emergency legislation, and I do congratulate the government for doing just that. There are many improvements in this bill over what was in the state of emergency bill, especially in the area of transparency and accountability. However, the extraordinary powers of the state of emergency were only intended to be exercised for 6 months at a time, although they were extended twice by this parliament. But this bill will entrench rule by decree without a time limit as long as a long-term normal state of affairs. In other words, a continuing state of emergency. This is not consistent with a functioning democracy and should not be allowed. We've had 18 months of experience with the pandemic, and we know what kind of powers are needed and could be specifically legislated to be enforced for a specific amount of time and should be subject to disallowance by Parliament. Now, I won't highlight every technical component in this bill because all others have already done so and probably will continue to do so, but I want to keep this relatively brief to give other members a chance to speak. But suffice it to say there's some serious issues. Let's start with the fines. Individuals and businesses in breach of public health orders could face $90,000 and $450,000 fines respectively. Now, in an upcoming amendment, we're told these fines have been halved now by the government, responding belatedly to consultation, but still very significant fines. Individuals can still be jailed for 2 years if they're deemed to have breached an order designed to keep the public or another individual safe. The bill confers enormous powers on the executive. The minister can make any order, detaining people or requiring medical examination of them. The right of review or appeal is extremely limited, limited to departmental officer, I believe. Detainees should have the right to a review in a court or at least at VCAT. And it does confer enormous powers on their so-called authorised officers to arrest and detain people, and it doesn't say for how long. So quite a bit of a worrying provision in an ongoing bill. I always believe with policing and law enforcement that the punishment should fit the crime, and that's why I find it a concern that my son or daughter, or any Victorian for that matter, could be plunged into financial ruin or go to jail because, in regards to any order, they ought to know that failure to comply is likely to cause a serious risk to the health of another individual. And that's a quote. As we know, the bill also authorises the minister to make orders which can discriminate persons or class of persons. And I'm glad to be told that in the government's overnight amendments They have clarified this to refer to a person's vaccination status rather than by reference to the Equal Opportunities Act 2010. As has been pointed out, referring to the latter can go as far as to include persons on the basis of their political beliefs or activities. As a Member of Parliament, our role is to listen to the community and to listen to our constituents and make decisions on their behalf, in their best interests. I've been listening to the community and listening to the odd 8,000 emails and hundreds of phone calls my office has received, all of which have been vehemently opposed to this bill. I've also listened to the Victorian Bar, the professional association for more than 2,200 Victorian barristers, which has sounded its concern over the extraordinarily broad powers granted to the Minister and lack of an overall time limit on the pandemic declarations. As they eloquently put it, the overriding concern is that the bill, if passed, may allow the Victorian Government effectively to rule the state of Victoria by decree for the foreseeable future without proper parliamentary oversight or the usual checks and balances on executive power. They add further, there are no real checks and balances in the legislation. There's no oversight at all by Parliament. Now, I do not share some members' faith, and Ms Patton's faith in particular, in SARC, even acting on the advice of the new Expert Advisory Committee, which I welcome, for SARC to refer matters to Parliament to be disallowed, as it is and always is a government-controlled committee. And in the unlikely event that SARC, as a government-controlled committee, recommended disallowance, it would not have to be disallowed. Such a disallowance would have to be a disallowance by both houses of Parliament, not either house. Now, as we know, that would not happen, would not get through the government-controlled lower house. That would be impossible for a disallowance to take place. It seems we have a government hell-bent on avoiding parliamentary oversight and disallowance at all costs, and this bill is no different to the previous states of emergency in that. Now, the newly appointed, as Ms Lovell pointed to, the newly appointed President of the Victorian Bar, Roseanne Annesley QC, said the Victorian Government proposed amendments to the Pandemic Management Bill, and they do not go far enough to protect the rule of law. The proposed amendments largely address low priority issues and not the most fundamental problems with the bill, she said. The major issues include the lack of effective parliamentary control over the Minister's pandemic orders and the lack of provision for an independent review of authorised officers' exercise of power. Now, the government and the crossbenchers will have to forgive me for listening to these QCs, the Law Institute and the community, over politicians with vested interests. These are genuine legal professionals. They could not, by any stretch of the imagination, be labelled as anti-vaxxers. And as a matter of fact, I've spoken to many, many people concerned with, about this bill. In this bill, the Minister, instead of the Chief Health Officer, will have the power to implement border closures, lockdowns, masks, vaccination mandates and the like, with virtually no real limit on time. This should require unconditional parliamentary oversight and disallowance, but it doesn't. Parliamentary oversight is essential to a functioning democracy, but the government in this bill seeks to kill vital aspects of democracy. I'd like to put on record that we do need a pandemic-specific legislation, but it needs to be measured and reasonable. This bill is still well over the top, and I can't support it. I do appreciate and support the government is allowing more accountability for its decisions rather than saddling us with decisions made by unelected bureaucrats, but unfortunately that positive component is far outweighed by the appalling negatives. To sum up, as we're all aware, the government has drafted this bill in secret with 3 crossbenchers, and it appears that they will be working with the government to steamroll this bill through. But it is a dangerous bill, and it urgently needs to go back to the drawing board. Those who support this bill in its current state are recklessly putting Victoria's future civil liberties in danger. I urge those 3 crossbenchers and members of the government, fix this bill. Don't just allow it to be steamrolled through and let future Victorians suffer the consequences.
Thank you, Mr Hayes. Mrs MacArthur.